What if a simple cybersecurity mistake, something you thought was just a technical hiccup, could actually land your company in a multi-million-dollar fraud case? Well, that's not a hypothetical anymore. For companies working with the US government, it's a new and very, very real risk. Today, we're diving into how cyber compliance became fraud. Just let that sink in for a second. We're all used to thinking of cybersecurity failures as, technical problems, something you fix with a patch or an update. But the game has completely changed. Now, the simple act of promising a certain level of security and then failing to deliver, even if no data is ever stolen, can be treated as fraud. That's the new reality we're breaking down today. So, yeah, we're moving from a purely technical problem to a huge legal one. This is a whole new kind of fraud we're talking about. And here's the absolute critical shift. The government doesn't even have to prove there was a data breach. The crime is the lie. If you certify to the government that you're meeting specific cybersecurity standards to win a contract, but you know you aren't, that misrepresentation is the fraud. End of story. So how are they pulling this off? What's the legal firepower behind it? Well, it's not some new cybersecurity law. Instead, the government has basically dusted off a powerful, old law and aimed it squarely at the tech sector. Meet the False Claims Act, or the FCA. This thing is the government's #1 weapon for fighting fraud. And now, a false claim can be as simple as sending an invoice from a company that isn't meeting the cybersecurity requirements it promised in its government contract. And the penalties, they are severe. The FCA allows for what's called treble damages. That means a company might have to pay back 3 times the government's actual losses, not to mention other steep fines. The financial hit can be absolutely devastating. So how do these cases even start? Well, they almost always begin with an insider, a whistleblower. They file a lawsuit on behalf of the government, which is kept totally secret while the Department of Justice investigates. And if the government wins, that whistleblower can get a massive reward, often in the millions. This right here is what makes the FCA so powerful. The law's Keaton provision, as it's called, essentially creates a government-sanctioned bounty for insiders to report fraud. It gives employees a huge incentive to become the first line of defense against these false claims. Now, this isn't just some legal theory they're floating around. It is an active, focused government strategy. And that brings us to the Cyber Fraud Initiative. You see, faced with increasingly sophisticated cyber threats and probably getting frustrated with companies self-reporting, the Department of Justice made it official back in 2021. They launched the Civil Cyber Fraud Initiative. This was a crystal clear message to all government contractors. If you fail to meet your cybersecurity obligations, we will come after you with the full force of the False Claims Act. I mean, this really shows you the fundamental shift. Before 2021, a cybersecurity vulnerability was a technical problem you had to fix, and maybe you'd get a fine. But after 2021, that exact same vulnerability, if you've told the government it doesn't exist, can be treated as fraud, with all the massive penalties that come along with it. And as this quote makes incredibly clear, the DOJ has drawn a line in the sand. When it comes to federal contracts, a cybersecurity promise is now a legally binding one. Ordinary little lapses are now extraordinary risks. Okay, so this is not some theoretical threat. The DOJ is actively pursuing these cases right now. Let's take a look at some recent settlements to see who's really in the crosshairs. First up, a settlement just shy of $1 million, and this one comes from the healthcare sector. So this company had a contract to provide medical services for the State Department. They claimed they were storing sensitive patient records on a secure electronic system. But they weren't. And remember, no data breach had to happen. The misrepresentation itself was the violation. Okay, next up, a much bigger case from the world of aerospace and defense. We're talking $9 million. That's right, Aerojet Rocketdyne, a huge defense contractor, paid $9 million to settle allegations that it had misrepresented its compliance with Department of Defense cyber rules. This case really proves that no contractor is too big to be held accountable. And a more recent settlement adds a whole other layer to this. $1.75 million. In this situation, the contractor was held liable for failing to implement required cybersecurity controls. But here's the kicker. It wasn't just the contractor on the hook. The company's private equity owner was also included in the settlement. This is a huge development, and it shows that liability can now stretch all the way up to investors. You know, the financial penalties are obviously steep, But for many government contractors, there's a consequence of an FCA violation that is even more terrifying. It's called suspension and debarment. This is basically the government's power to blacklist a company, stopping it from getting any new federal contracts. For a government contractor, this is pretty much a death sentence for their business. And the effects are just brutal. A debarred company gets no new federal contracts. They can't even work as a subcontractor on federal projects. Their name gets published on a public exclusion list for everyone to see. The financial and reputational damage can be absolutely catastrophic. So we'll leave you with this question. Is your cybersecurity program just a technical control, or is it a legally binding promise? Because under the Civil Cyber Fraud Initiative, there's really no longer a difference. And for any company working with the government, understanding that distinction is now one of the most critical challenges they face.